Hello and welcome, friends, especially those of you who still believe in the power of principle, the value of respectful debate, and the enduring strength of our Constitution. If you've ever wondered whether truth still has a place in public service, this moment will restore your faith. So settle in and witness how Karoline Leavitt turned a gavel into a conversation and left a legacy no one saw coming. The clock on Karoline Leavitt's mantle read 2:13 a.m., but sleep hadn't come and wouldn't. Outside her Washington apartment, the streetlights flickered across the Potomac like old memories, quiet, steady, and watchful. Inside, she sat at her kitchen table, surrounded by stacks of legal casebooks, a yellow legal pad filled with handwritten notes, and a well-worn copy of the Constitution, pages dog-eared from years of quiet study. She had turned off the television hours ago, muting the pundits, the speculation, the mounting pressure. Across town, White House counsel had already drafted an official apology, carefully worded, politically safe, and signed off by senior staff. All Karoline had to do was read it aloud in front of the Supreme Court, issue a public retraction, and walk away with her job intact. But as she flipped through the pages of Bridges v. California for the third time, her fingers trembled, not from fear, but from resolve. This wasn't just about one statement or one press briefing. This was about whether truth, spoken plainly, even when inconvenient, could still survive in American public life. A photo frame nearby caught her eye. It was her old professor from St. Anselm, Dr. Marcus Whitby, smiling in front of a chalkboard where he once wrote, "Courage isn't volume, it's clarity when silence is safer." He had once told her she was born to argue ideas, not spin narratives. That voice echoed now, studied law by night, while working full-time by day, quietly, deliberately, without ceremony, and now, with 9 justices waiting and the world watching, she found herself at a crossroads where preparation met conviction. The easy road led to surrender and silence. The harder path, the one history would remember, led straight into the lion's den. She closed the folder, took a breath, and whispered into the silence, "Let's argue this properly." In the pre-dawn stillness, she wasn't thinking about cameras or headlines. She was thinking about duty, to country, to conscience, and to the Constitution. Tomorrow she would not beg for mercy. She would argue for principle, and whatever came next, she would meet it standing. The polished oak doors of Constitution Hall swung open at precisely 9:00 a.m., and the murmuring crowd inside fell silent. Journalists, law clerks, retired judges, and constitutional scholars sat shoulder to shoulder in the tiered gallery, their eyes fixed on the marble dais where the 9 justices of the United States Supreme Court would soon convene. The venue, chosen for its symbolic blend of tradition and modern transparency, glowed under natural skylight. But there was nothing soft about the atmosphere. Everyone knew this wasn't just a hearing, it was history waiting to happen. Then came the sound that would mark the beginning, one crisp strike of a gavel. Justice Amy Coney Barrett, seated at the center of the bench in her black robe, leaned forward. Her voice, honed through decades of legal discipline, was sharp but measured. "This court is now in session. The matter before us is the potential contempt of court by Ms. Karoline Leavitt, White House Press Secretary, regarding public statements made following our decision in Riverstone v. United States Department of Education." A quiet gasp rippled through the gallery. Cameras weren't allowed inside, but the transcript would be broadcast live within minutes. The stakes weren't just about legal precedent anymore. They were about the balance of power, the freedom of expression, and whether the executive branch could publicly disagree with the judiciary without legal retribution. Karoline Leavitt rose from her seat at the front of the chamber. At 28, she looked calm, composed, far from the firebrand some media outlets had painted her to be. Dressed in a simple navy suit, her expression was not defiant, but focused. She carried no teleprompter, no legal counsel at her side, just a leather folio worn at the corners filled with handwritten notes, printed precedents, and one annotated copy of the First Amendment. Justice Barrett continued, "Ms. Leavitt, you have been summoned before this court not as a private citizen, but as a representative of the executive branch. Your recent public statements have been interpreted by some as undermining this court's authority. You have 7 days to issue a formal retraction and apology, or this court will consider referral for criminal contempt." The room held its breath. This was the moment everyone expected her to fold, to read the prepared statement from the White House counsel, apologize, and retreat. But Karoline didn't flinch. She stepped forward, placed the folio on the podium, and met Justice Barrett's eyes. "Your Honor," she began, her voice unwavering, "with the court's permission, I'd like to respond not as a gesture of defiance, but of constitutional duty." Justice Barrett's eyes narrowed. "Proceed, but be advised your response may factor into the court's decision." In that instant, the entire tone of the proceedings shifted. No longer was it about reprimand, it was about reckoning. The gavel had fallen, but the outcome was far from settled. Karoline Leavitt took one steady breath, opened her folio, and began, not with bravado but with measured clarity. "Honorable Justices, I appear before you today not in opposition to the court, but in service to the principles that give it meaning." Her voice didn't rise. It didn't need to. Her words were crisp, every syllable chosen not for effect but for accuracy. She spoke not like a political operative, but like a student of the Constitution, with something worth defending. "I recognize the gravity of this moment, and I approach it with the utmost respect, not only for this court, but for the balance of powers our founders so carefully designed." Justice Nolan Creed, a longtime skeptic of executive speech, leaned back, arms folded. Justice Miriam Stone narrowed her eyes. Across the gallery, pens began scratching again. Some came to see a rising star falter, others to witness a battle. What they were hearing instead was restraint, thoughtfulness. "I'm aware that my role as White House press secretary carries weight," Leavitt continued. "But that role does not suspend my obligation to truth, nor does it strip the public of its right to hear candid, constitutionally sound critiques of judicial reasoning." She paused, just long enough to let that distinction sink in. She wasn't questioning the authority of the court. She was questioning how far that authority reached in limiting public discourse. Then she laid the cornerstone of her defense, the First Amendment. Pulling a folded page from her portfolio, she read aloud from Bridges v. California, a 1941 Supreme Court case. "The substantive evil must be extremely serious, and the degree of imminence extremely high before utterances can be punished. This court," she said, looking directly at Justice Barrett, "has long held that criticism, even sharp criticism, of judicial decisions is protected speech, unless it presents a clear and present danger to the administration of justice. My statements, while pointed, presented no such danger. They were legal assessments, not personal attacks." She wasn't yelling, she wasn't posturing. Instead, she was modeling the kind of civil disagreement that so many Americans, especially those who'd watched civic discourse deteriorate over the years, yearned to see again. Justice Barrett gave no reaction, but her pen, which had been idle, began to move. Justice Graves leaned toward her microphone, then paused, choosing instead to listen. As Karoline continued, she never once raised her voice, but in that chamber designed to intimidate, she was quietly redefining what power sounded like. Not volume, not politics, but principle. In an age of performance and outrage, what she offered instead was something older, something enduring, a reminder that the Constitution isn't preserved by shouting, but by those willing to speak truth with reverence, even when it's hard. Karoline Leavitt turned the page in her folio and continued her presentation with the poise of someone who understood exactly where she stood and what it meant. In New York Times v. Sullivan, this court established that debate on public issues should be, quote, uninhibited, robust, and wide open. That ruling emphasized the importance of allowing even sharp and uncomfortable criticism of public officials, including members of the judiciary. My remarks adhered to that standard. I was direct, but not disrespectful. She looked up from her notes, and for a moment the chamber remained still. Then came the first direct challenge. Justice Adrian Kessler, known for his strict textualism and sharp tongue, interjected. "Ms. Leavitt," he said, his voice clipped and firm, "your statement accused this court of ignoring 70 years of precedent. That is not a legal critique, It's a veiled attack on our integrity. How do you reconcile that with the obligation to maintain public trust in the judiciary?" Karoline didn't flinch. "Justice Kessler," she said, "my statement challenged the legal reasoning of the majority opinion, not the character of the justices. If we conflate criticism of ideas with attacks on integrity, we risk turning disagreement into disloyalty. That's not only dangerous, it's un-American." A murmur rippled through the gallery. Reporters typed furiously. Justice Miriam Stone leaned forward, arms resting on the bench. "But as a representative of the executive branch," she pressed, "your words carry institutional weight. Doesn't that elevate your responsibility to preserve deference toward the court?" Karoline responded with calm precision. "Justice Stone, deference does not mean silence. The public deserves transparency, not a curated illusion of unity. I referenced case law and historical precedent. That's not incitement, it's dialogue." Justice Lenora Graves joined in, her tone more inquisitive than combative. "You're arguing that your speech was protected because it didn't pose a clear and present danger to justice. But this isn't just about First Amendment rights, it's about the boundaries of institutional respect. Do you acknowledge any limit at all to your commentary?" "I do," Karoline said, without hesitation. "If I had urged the public to disregard a court order or called for open defiance of a ruling, that would cross the line. But I did no such thing. My critique was legal, not revolutionary." She paused, then added, "This court itself, in Craig v. Harney, held that what transpires in the courtroom is public property. My remarks were grounded in that very tradition, that citizens, including public officials, may scrutinize judicial reasoning without risking their careers or their liberty." Justice Barrett, who had thus far remained mostly silent, now spoke again. "Ms. Leavitt, you've cited cases about private citizens and the press, but you are neither. You speak with the implied authority of the president. Shouldn't that distinction matter?" Karoline turned to a bookmarked section of her notes. "Your Honor, that distinction is important, and this court addressed it in Lane v. Franks. There, you affirmed that public employees speaking on matters of public concern retain robust constitutional protection. My comments addressed a major federal education ruling, a subject of deep national interest. I was not speaking as a bureaucrat delivering internal messaging. I was speaking in my public capacity, addressing the public consequences of a legal decision." Barrett tapped her pen once against her binder but gave no visible reaction. Still, the dynamic had shifted. What began as a disciplinary hearing was rapidly transforming into a legal seminar of the highest order. The justices were no longer dealing with a rogue staffer. They were contending with a formidable constitutional interpreter. Justice Darnell Ford, who rarely spoke during hearings, cleared his throat. "Ms. Leavitt, your command of precedent is impressive," he said slowly, "but you haven't addressed the practical concern that statements like yours erode confidence in the court at a time when public trust is already fragile." Karoline nodded solemnly. "Justice Ford, public trust is strengthened, not weakened, when public officials speak truthfully and transparently. When we allow reasoned criticism to be silenced under the guise of decorum, we erode something far more precious, the people's right to question authority." Silence returned. Not the uneasy silence of confrontation, but the dense, thoughtful quiet of a courtroom that had just been given something to chew on. The justices were no longer debating whether Karoline Leavitt had crossed a line. They were debating whether the line should have been drawn there in the first place. Karoline Leavitt closed her folio momentarily, not out of hesitation, but to look each justice in the eye. What came next wasn't another legal citation, it was memory. It was legacy. "Your Honors," she began, "I understand the concern about public trust, but trust in the judiciary has never depended on silence. It has endured, because this nation has always allowed, even expected, its leaders to speak with courage when the stakes are high." She reached again for her notes, now holding a printed page titled "Executive Critique Through the Ages." The first name on it, Thomas Jefferson. President Jefferson once called this court's ruling in Marbury v. Madison, now one of the most famous in history, "twistifications of the law," she said plainly. He believed the court had overstepped, and he said so. No contempt proceedings followed. Karoline turned the page. President Andrew Jackson, she continued, famously responded to a Supreme Court ruling by saying, "John Marshall has made his decision. Now let him enforce it." Reckless? Perhaps. But also a reflection of the tension our system was built to withstand. Tension between branches is not dysfunction, it is democracy, doing its work. The gallery was now utterly still. She had left legal jargon behind and stepped fully into the language of American tradition. And then came the moment many weren't expecting. She reached into the modern era. In 2010, President Barack Obama, during a State of the Union address, directly criticized this court's decision in Citizens United v. FEC. 6 justices were seated in the chamber when he did so. He said the court had reversed a century of law and warned it would open the floodgates for special interests. Karoline paused. That statement was televised, pre-written, and watched by millions. No contempt threat was issued. Then, with deliberate care, she added, in 2017, President Donald Trump referred to a federal judge who ruled against his administration as a so-called judge. Many objected to the tone, but again, no legal consequence followed. Her voice remained steady. These are not footnotes. They are precedent, not in case law, but in constitutional behavior. When presidents have disagreed with this court, they have said so forcefully, sometimes provocatively, and the Republic endured. Justice Stone leaned slightly forward. "And what do you believe that says about your case, Ms. Leavitt?" Karoline answered without missing a beat. That the ability to criticize judicial reasoning, respectfully, directly, and publicly, is not a breakdown of institutional respect. It is proof that our system still functions. It means we have not replaced reverence with fear. Behind her, even those who came expecting contrition were now watching with quiet respect. She had not only defended her own actions, she had placed them within the lineage of America's most iconic voices. The chamber was still echoing with the names of Jackson, Lincoln, and Obama when Karoline Leavitt turned the page one final time. This time to a document that bore no Supreme Court seal, no majority opinion header. Instead, it bore a byline. Amy Coney Barrett, Notre Dame Law Review, Volume 94, Issue 1. Karoline didn't raise her voice or change her tone. She simply read the words aloud, each syllable ringing with clarity and weight. Respectful disagreement is not disrespect. Indeed, the ability to challenge judicial reasoning in the public square is essential to the health of our constitutional democracy. A sudden quiet swept the room, different than before. This silence wasn't just solemn, it was stunned. Justice Barrett herself had written those words just a few years prior, long before she ascended to the nation's highest bench. Now, they were being returned to her, not as a weapon, but as an appeal to consistency, to principle, to the legacy of her own thought. Karoline paused, then looked directly at the justice whose gavel had opened this hearing. "Justice Barrett," she said respectfully, "those are your own words. I cite them not to embarrass, but to remind us all that when we engage in public discourse about law, precedent, and interpretation, we are not eroding democracy, we are participating in it." Barrett's expression did not break, but the shift was visible to those who knew how to read it. Her pen stopped moving, her shoulders, rigid minutes ago, eased just slightly. The judicial mask didn't fall, but it flickered, and behind it the mind of a scholar was at work. Across the bench, Justice Graves leaned back slowly. Justice Ford tapped a finger once, then rested his hands. They too recognized what had just occurred. Karoline continued, gently but unwavering. "When I said the court had misread 70 years of precedent, I did so in the context of legal methodology, not moral condemnation. My critique was sharp because the moment demands clarity, but it was never personal, it was never political. And I submit that your own scholarship affirms that space must be preserved, not just for the press or private citizens, but for public officials tasked with communicating the stakes of constitutional interpretation." A beat passed. No one moved, not even the stenographer. It was the kind of moment older Americans know well, the stillness before the truth lands, when an argument becomes more than words. Karoline had done more than defend herself. She had built a bridge between dissent and duty, between precedent and principle, between the courtroom and the country. Justice Barrett didn't respond, not yet. But she no longer looked like a judge preparing to deliver punishment. She looked like a jurist, absorbing a mirror held up by someone who understood her, quoted her, and respected her enough to challenge her, on her own ground. As Karoline Leavitt stepped down from the podium, a slow, stunned silence blanketed the chamber. There was no applause, it was not permitted. But in the hushed breaths, the quick glances among justices, and the stillness of the gallery, something irreversible had happened. Outside Constitution Hall, a crowd of reporters surged behind barricades. Camera lenses clicked like rain against metal. Cable news stations interrupted their programming. "Unprecedented confrontation," one chyron read. "Press secretary defends free speech in court," flashed another. Within the hour, Karoline's quotes were trending on social media, but more notably, on talk radio, in veterans' halls, in quiet conversations in diners and front porches across the country. At the Heritage Foundation in D.C., a constitutional law roundtable was hastily convened. At Harvard, students packed an auditorium to watch the live stream of panelists parsing her legal citations. Even at local American Legion posts in Kansas, Florida, and Michigan, veterans gathered to watch the clips play again. One retired Marine said what many were thinking: she didn't just speak for her party, she spoke for the Constitution. On Facebook, users shared video snippets of her quoting Justice Barrett with captions like, "Finally, someone speaking with principle, not performance." In nursing homes, longtime voters who remembered Watergate and Vietnam told their grandchildren, "That girl understands how it's supposed to work." TikTok lit up with tributes from law students, many of them young women, lip-syncing her courtroom lines with awe. But among the most powerful reactions were from viewers aged 50 and older, who hadn't expected to be moved, and certainly hadn't expected to be reminded of why they once believed in public service. This wasn't just a legal moment, it was a national one. Karoline Leavitt had entered Constitution Hall accused of contempt and walked out having stirred a country's conscience. For a generation that feared the values they held dear were slipping away, what they had just witnessed was something rare, a principled stand, calmly made and powerfully heard. 2 days later, at precisely 10:00 IEM, the Supreme Court released its decision. The statement was brief, just under 2 pages, but its impact was seismic. By a 9-0 vote, the court declined to pursue contempt proceedings against Karoline Leavitt. The language was restrained, almost clinical, but tucked between the lines was a recognition of something profound. While this court maintains its authority to protect the dignity of its proceedings, it read, we are also bound by the constitutional limits of that authority. Ms. Leavitt's remarks, while critical, fall squarely within the protections guaranteed by the First Amendment. A concurring opinion from Justice Barrett followed, more personal in tone. Democracy, she wrote, requires room for disagreement. And disagreement, even pointed and uncomfortable, should not be mistaken for disrespect. Ms. Leavitt reminded this court and the country that robust debate, when carried with reason and civility, is not a threat to our institutions but their proof of life. The ruling spread quickly. Cable anchors read the decision on air, legal scholars posted instant reactions, headlines across the political spectrum converged on one undeniable point. Leavitt had stood her ground and won, not with outrage, but with argument. The New York Times called it a masterclass in constitutional restraint. The Wall Street Journal wrote, the youngest press secretary in history just revived the art of respectful dissent. Across the country, in libraries, churches, and civic centers, Americans who had once feared that their Constitution was being reduced to a relic now saw it tested and upheld. Inside the White House, staffers gathered in the West Wing conference room to watch the ruling come through. The president, who had once urged a more conciliatory approach, called Karoline minutes later. His voice, typically brisk, was quiet. Whatever history books say about this administration, he told her, they'll remember you stood tall when it counted. Karoline offered no victory lap. At her next briefing she spoke only briefly. "I'm grateful the court engaged with the constitutional questions. I spoke with respect for this institution, and I believe that respect was mutual." And across America, millions nodded. She hadn't just won her case. She'd reminded the country what principled leadership looks like when the cameras are rolling. And when they aren't. 6 months had passed, and the storm had long since moved on. But inside a packed auditorium at the University of Notre Dame, it was clear. The legacy of Karoline Leavitt's stand was only beginning to unfold. Students lined the aisles, professors filled the wings, and C-SPAN cameras rolled quietly in the back. The lecture hall hadn't seen this kind of attendance in years, not for a court justice, and certainly not for a press secretary. But today was different. Today, Karoline Leavitt was not behind a podium answering questions. She was delivering a lecture on executive speech and judicial dialogue. And introducing her was none other than Justice Amy Coney Barrett. Barrett, dignified and poised, stepped to the microphone first. 6 months ago, she said, I expected to preside over a disciplinary hearing. What I received instead was a constitutional exchange, firm, principled, and unshakably respectful. Ms. Leavitt did not come to undermine the court, she came to challenge us. Within the framework we swore to protect, she paused, then added with a faint smile, and she quoted me with such accuracy that I had no choice but to listen. The room erupted in warm, knowing laughter. When Karoline approached the podium, she didn't speak as a political figure or even as a media figure. She spoke as a citizen, one who had once stood alone before 9 of the most powerful jurists in the country and chose principle over protection. Respect and disagreement are not enemies, she began. They are siblings in a healthy democracy. I did not go to Constitution Hall to win. I went because silence, in that moment, would have meant surrendering something too precious to trade. The right to speak honestly, even when it's uncomfortable. She spoke for just under 20 minutes, but in that time she traced a line not only through case law, but through American conscience. She quoted Lincoln again. She referenced Jackson, not for his bluster, but for his belief in balance. And when she concluded, she didn't speak of herself. She spoke of all those who come next, young women, public servants, lawyers-to-be, who might one day be asked to choose between compliance and conviction. The applause was thunderous, sustained, but for those in the room who remembered the beginning of her journey, what mattered more was the stillness that followed. Because in that stillness, a truth settled in. Leadership isn't loud, it's principled. And in Karoline Leavitt's case, it left a legacy no gavel could silence. In a time when public discourse often feels dominated by outrage and spectacle, Karoline Leavitt's quiet stand before the Supreme Court offers a powerful reminder: principle still matters. She didn't storm the chamber with slogans, she entered with law, precedent, and respect. And in doing so, she proved that courage doesn't always come dressed in defiance, it often wears the robe of reason. The story teaches us that disagreement, when rooted in truth and delivered with civility, is not a threat to our democracy but one of its most vital expressions. By standing firm on constitutional ground, Leavitt didn't just defend herself, she defended the right of every citizen to speak honestly about the institutions that shape our lives. Older generations, especially those who lived through the civic clashes of the 1960s and the institutional reckonings of Watergate, know how fragile and essential that right is. What Leavitt showed is that it can still be exercised, not through rage, but through resolve. The courtroom didn't need a firebrand, it needed a patriot with clarity, respect, and conviction. That is the legacy she leaves, not one of noise, but of enduring voice.